All right. Good afternoon, everybody. Sorry, we had a bit of a technical issue getting started. I'm going to wait a few seconds here. The participants are rolling in. Let's give us like 1 minute and then we're going to get started here. All right, people are still trickling in, so we're just going to get started. Thanks for being here, everybody. Obviously, we're starting a little late. That's my fault. I'm not the best at getting things like this organized. We've got about an hour set aside. There's going to be some time at the end if you've got questions. But if you've got questions throughout the presentation, there's a chat box in the lower part of your screen. If you look, it's probably in about the middle. Just click on chat and type your questions in there. We'll try to get to them throughout the presentation, but if not, there's a little bit of time set aside at the end. Today the issue is millennial jurors and judges that are new to the bench. We've got with us today Slater Elza. He's a heavy hitter from Texas at the Underwood Law Firm. He represents multiple different types of business entities as well as government entities. He's tried over 125 cases in federal court, state court, in states all over the country, New York, New Jersey, Texas, obviously, Louisiana. He serves as the president-elect currently of the Texas Association of Defense Counsel. He's also on the litigation council for the state bar down there in Texas. So again, he's here to talk about millennial jurors, which is one of the biggest growing populations when it comes to jury pools, as well as judges that are newer to the bench than other judges. So with that, Slater, I'll let you take over.
All right, thank y'all for having me. So for the past 2 years, I have sat around and I've griped and I got mad and I got disappointed with our young lawyers, who we call millennials, because I thought that they didn't care and I thought they had no attention span. And I ignored that a lot of our older lawyers didn't always care and didn't always have a really good attention span. And then, as was just mentioned, I was on the State Bar Litigation Council for Texas that kind of oversees our litigation section. And we had a president that year, and she found a consultant to help us understand millennials. And as we got ready for that, they talked about millennials like they weren't human or they were something that we had never seen. And this consultant was smart and engaging and a millennial, and she was about as annoying as you can be, and I was pretty convinced that I hated her. But we listened to her about 4 different meetings for about 2 hours at a time, and there was one thing that she said that kind of changed the way I saw all of this. I'm sure she said many other wise things, but the one that really got to me was she said, you know, millennials don't want to make decisions. They don't necessarily want to be the boss. They want to be invited to the conversation. And she was talking about our young lawyers, but all of a sudden it started making sense for a generation. She said, you know, they like the interaction. They like being a part of the team. And so I started thinking about my firm, which is about 50 lawyers, most of them here in our home office, a couple of others spread around Texas. And I started looking at the lawyers who did best working with millennial lawyers. And they were the lawyers that like to collaborate, or they were the lawyers like me that talk too much and enjoy talking. And so we realized that the people who succeeded the most with millennials were those that invited them to the conversation. It was not the lawyers who sent tasks by email and expected a memo to be dropped in their box or returned by email. It was the ones that interacted. And so during this time, I went to about 27 CLEs, and just like all of y'all, every one of them seemed to have a topic about millennials and millennial jurors and how they were going to ruin all of our careers. And then I started learning that the plaintiffs' lawyers were having CLEs about how the millennials were going to ruin their careers. And the people doing employment law on both sides of the bars all had CLEs about how millennials were going to ruin their careers. So I thought, I'm interested, I'm going to commit, and I'm going to study. So I read some legal journals. I collected CLE papers, probably some of the ones y'all have in your file cabinets. I even started reading some millennial blogs, started looking at some Instagram posts. And then I started trying to figure out, how do you reconcile all of this information that is out there that contradicts itself and that looks at the problem without really looking at the solution? What I kept seeing was a lot of people who were saying, well, if you have a mixed jury generationally, and you will every single time, you need to do it this way for the young people, this way for the middle people, and the third way for the old people, which means that you are going to be a hot mess with little chance to succeed if you are scattered and trying to be all things to all people that you are assuming are so different. And so I started thinking, the one overriding thing before we jump into the actual presentation, the one actual thing that everybody can agree on is this is really the first generation that's been raised mostly or almost entirely in this new age of information, internets, and the computer access in schools and phones that have access to anything you want. And that does make them different than us with gray hair who did not have that when we were their age. But then I also started thinking, nobody uses their phone more than I do. Nobody reads the news on their phone more than I do. Nobody goes on Twitter more than I do. So, or maybe they a little more like me than I wanted to admit. Then I started thinking about my mother, who's approximately 75 years old, and a lot of the same things. She is on the internet. She is on social media. She gets her news on her phone or her iPad. And then I started thinking about my 99-year-old grandmother who passed away a couple of years ago, and how she did things differently than she'd done her whole life, because she got emails or texts, and she got pictures of her grandkids and her great-grandkids and her great-great-grandkids. And so she used technology, obviously, more than anybody of her generation had previously. So all of this, I started thinking, and in the spin that I think is a little different, and it's not unique, there are other people out there, I think, that believe this, is, are millennials really as different as we want to think they are, or are they the generation that we can look at and that we can study, and they can really help us understand how better to try cases, how better to prepare our cases by looking at the similarities among the different generations. So as we go through here, we're going to tie it up at the end, hopefully, but as we go through here, what I want you to be thinking about is, as we see all of these characteristics of millennials and all of these things that people tell us we need to be doing to deal with millennials, is that really the pathway to trying successful cases as opposed to the disaster? Really, if you read the blogs, that everybody is convinced of this. So we will go ahead and hop into the actual presentation. So who are millennials? They're 23 to 40-year-olds. I mean, it's a big span of ages. The difference between 23-year-olds and 40-year-olds is immense. It's about 1/4 of the population. You start seeing that in many firms, it's 1/3 to 1/2 of the lawyers that are there. You start looking at juries, and I think as we come out of this pandemic, it's going to be a huge percentage of our jurors as older people with compromised health situations opt out. As we have in certain states, the ability to opt out at 65 or 70 years old from jury service. This is going to be a huge part of our juries. And again, I think it's an opportunity not an obstacle. So what do we know about them? As you would believe, they're more racially diverse than any age group that's out there. 1/4 speak another language. They are less well off financially. I think on the next screen, we'll see that they're the highest educated generation, but again, have kind of hit double bumps in the road on finances. They are more politically liberal, which scares defense lawyers, but you have to understand how that liberalism manifests itself to understand really what we're dealing with. And again, most importantly, there at the bottom of that screen, they are a generation whose lives have been shaped by technology. Again, if we think about other generations, that's not so scary because their lives from the beginning, in some sense, have been shaped by technology, but the rest of our lives and the other generations, our lives have been incredibly shaped by technology now for 20 plus years. So again, more of a commonality than I think a lot of speakers have given credit to over these past couple of years. Again, best educated group, huge percentage based on or compared to the past on having 4-year degrees. Now, this next part is true, but we've got to try to understand it. So they are less tied to traditional institutions. Less willing to say that they are a Democrat or a Republican, but they do seem more liberal than other age groups. There is a lot of spirituality, but less affiliation with religious institutions. And I think that's not going to be a huge surprise for anybody when we look at the rise of evangelical churches, non-denominational churches. That is driven by this new age group, but it's also you don't go in there and everybody's under 40. I mean, there are multiple generations that with access to new and different information have chosen to look at religion and spirituality differently. Marriage is really probably a progression. We've seen the importance of marriage decrease, but that's not just in this generation. We've seen it through past generations or previous generations. We've seen it with the rise of divorce. And so again, something that's probably not terribly different. It's just kind of from the beginning as opposed to evolving through the others. One of the traditional institutions that I don't have on this, but I find very interesting. As many of us were growing up, your evening began or ended with watching the network news. You had 3. And they were all pretty similar. And that is where people got their information. They might have access to one newspaper. And so we had the institution of national news that gave one view of any issue. And it's probably a pretty down the middle view of any issue. Very different now. You can watch any show you want and you can make sure that they're going to say something exactly the way you want to hear it, exactly the way you believe in it. And that has been a huge change in the way that we transfer information. And again, as we think back, and if you'll think back to growing up or to your young adulthood and what an institution evening news was, again, very big change that this generation is not familiar with. But what they are familiar with is the access to all of this information, which is the same information that we have access to. They are more opinionated and progressive. This is the one that makes trial lawyers think, wow, that's a little scary because, you know, we convince ourselves as we pick a jury, well, we want to make sure we get some opinionated people on there, but we want to make sure they agree with us. And we've all had juries, probably every jury that has opinionated people that are against us. And how do we deal with that? So it's not different, but you know, in the past, I think we thought young people would be more followers, maybe not necessarily the case today. So let's think about millennials as jurors as opposed to just citizens. And I have found something to justify all of these out there. You will find the personal injury plaintiffs thinking that millennials are very tough, liability jurors. They value personal responsibility. Plaintiffs' lawyers will say that they are sometimes worried that when they're looking at personal responsibility, that they are shifting blame or willing to shift blame to personal injury plaintiffs. This is a virtual room full of defense attorneys, and I spend my days in rooms of defense attorneys, and we are all convinced that as we represent corporations and drivers that have been sued or whatever your practice is, that millennials are our enemy. And there's a basis for being worried because we have a generation that is very safety conscious. And, I don't think it's surprising that over these past few years, we've seen the rise of the reptile theory, which we'll talk about a little bit more later. But again, so we've got plaintiffs worried, plaintiffs counsel, we've got defense counsel worried. This is an article I read recently. I just added to this slide. Employment lawyers who work on the plaintiff side don't like millennials because they're convinced that they're tough on employees. Millennials are job hoppers. They're not like me. They don't come to my firm and 25 years later, they're still here, and 25 more years, they're still going to be here. They are job hoppers, and when you have people who hop jobs, I wasn't happy here, or I thought I could be happier somewhere else. Okay, make the decision, go get another job and move on with life. Again, changes the way that a plaintiff employee might be seen. But one of the most important things that I think we can take out of this is millennials trust themselves to find the answer. They have never really lived in a time where they could not Google and get an answer. Now, some Google to get the answer they want. Some Google multiple websites to find different views so that they can select an answer. But regardless, that is there. When I was young, on Thursday night before my Friday paper or project was due, I would tell my mom, oh my gosh, I forgot to do this. And she would take me to the library and the resource guy would help us find some information. It's not like that anymore, but it's not like that for anybody. As you sit there with your parents or your siblings who are middle-aged and more, and questions come up, the first thing everybody does, you look down and again, you Google. So remember, as we're looking at our theme here for how we can find commonality as opposed to differences, it may be the only way they've done it, but it's much more similar to the way we do things across generations today. So straight out of that, they're very comfortable with technology, the world in their pocket, as it is for most. This is a generation where we first started to see a change, that they're not willing to just trust the opinion of a doctor or an expert that just tells them what the answer is. They want more. They're used to being able to find the rest of the story. They have short attention spans. I would argue to you, I think we all have shorter attention spans than we used to. And people will say, depending on which path you choose, that this is the CSI effect or this is the Law and Order effect. The Law and Order approach to trials. You watch Law and Order and you see some investigation, and then you wrap it up and you have 3 witnesses that each get 4 questions, the last one of which is always withdrawn, and you get a verdict. And so that is what we tell people about how trials are conducted. Really probably not a lot different than the old Perry Masons or the Matlocks, but it is a big part of TV. You can flip through, and on any given evening, at any given hour, there's Law and Order and CSI. But I got to thinking, my 99-year-old grandmother passed away in good health and happy and at home. When we would come to visit, we would sit in the next room where the fireplace wasn't melting your skin, and you would hear the Law and Order theme music and the Law and Order transition bump-ums, and she watched it all the time. So again, is it just our young people who have been exposed to that? Absolutely not. This last bullet point and sub-bullet point, Millennials in actual investigations and interviews that have been done are more likely than older generations to flout a judge's instructions. And that is worrisome. And I think you have to stop and think about what is out there that might affect your case and assume that multiple jurors are probably on the internet. Now, the next subpoint says 31% would be inclined to do their own research on the internet during the trial, which we all know means against the judge's instructions. But I don't think you can say that that is just young jurors. Maybe that young jurors are the only people, are not the only people, but are more likely to admit that they would do that. And people of older generations have a little more respect for institutions, at least when they talk out loud. So how do we start figuring out what this means to deal with youngsters and make those lessons apply and benefit us with all of our potential jurors? Because again, I do not think this 3 approaches to 3 different generations in one trial ever leads to a great result. So we have the reptile theory. Every one of us have been to courses, we've read books, we've read papers, and we have been whooped by it, and we think we have solved it, and then we go start over. And the Texas legislature is meeting Tuesday, to try to pass laws that ban the reptile theory. And so it is a huge part of all of our practices. But how do we counter that? Because it is out there. One of the things that we see from the studies that works with millennials is really individualizing things. Helping them see that businesses are made up and run by individuals, that companies do not spend every day trying to find out how to lie, cheat, and steal, but instead how to do what is good and right and best, not just for their customers, but for their employees and by extension, their employees' families. And you can say, well, Slater, that is absolutely nothing new that you share there. But I think it becomes much more important to humanize these brick and mortar type organizations. We focus on the type of business and what they're doing and how they're made up and who they're made up of across generations and how they're like us. And again, these sound like platitudes and sound bites, but I think they are much more important. Again, and it's not going to hurt you with any other generational jurors that you have out there. What is your client's story? And again, you're going to hear me start saying in a little bit, we've got to really start narrowing things down. So why are you saying that we are kind of expanding what we're doing? So I really think this is a foundational issue, and it's a foundational issue that has to start in voir dire, and it has to be looped back around when we get to closing, as we'll talk about on this next slide. But these people who are progressive and everybody talks in sound bites to be offensive. Liberal is a bad word, conservative is a bad word, progressive is the worst word right now, and unless one of those matters to you, and then they're not offensive at all. But one of the things that we as defense attorneys, because again, we're on the wrong side of lawsuits, right? When they're filed, there's some reason out there that makes somebody think that we're bad or that our clients have done bad. So, the approach that seems to be working best with millennials and I think even with judges and hearings and bench trials is this idea that you can be progressive, you can be more liberal. Part of that is protecting your communities, not from safety issues like reptile theory focuses on, but you're a defender of your community's conscience. You're standing up for the truth, willing to listen and make a decision based on what's in front of you instead of what somebody's simply telling you to do. You're talking in voir dire about having the courage to make unpopular decisions, or that you feel, that you just need to go along with the crowd. These are all parts were similar to questions that we've asked for 25 or more years. They're much more important at this point in time because, again, it's about bringing us back to voir dire. And again, I'm in Texas. In state voir dire, we have great latitude on what to ask. In federal court, we have little to none, much like y'all. A lot of this is going to depend on what your judge will let you do from a time standpoint. But I think these are priorities that with whatever you have to work with in voir dire, that you are incorporating, maybe, to the exclusion of some of the more traditional questions. So, this is probably not that different in many ways from what a lot of us have always learned. It says, let them tell you what they think. We've always wanted people to answer open-ended questions, but from there, what do the experts teach us to do? They teach us to get a good answer and loop that back around. So, Ms. Smith, you would agree with that. Mr. Jones, doesn't that make sense to you? Maybe not the most perfect approach with younger people. It may not be a tried and true approach that you do on every question anymore, because you don't want them to think you're trying to box them in, that there's something that is not genuine about what you're wanting to do. You've got to give them some flexibility. Now, in every group, we have followers, and making sure you get those followers into a jury with some strong leaders for your side. Again, case by case basis, we're going to look at that. But again, we've got to start thinking about how do we get information transferred from the jury to us. And I think with younger people, it is more important to give them a chance to speak. Beware of millennials who are too eager to get on the jury. I've read a lot of articles, and I think one thing that we can all agree on is some millennials see jury service as a chance to make a difference. Kind of like in all of our careers, you wonder about the elderly person who has an exception they can claim but says no, they want to be on a jury. Is that because they have an agenda? I think usually we thought that's because they're bored. But how does that affect our case? I think in this day and age, the idea of millennials wanting to make a difference and trying too hard to get on a jury is something that you have to worry about. Again, probably going to apply to other generations, but with the younger juries, a little scarier for us. Millennials, just like any generation, I think, that want too hard or too much to be on a jury, you have to make sure you understand what they're doing. Again, they are more likely to talk than some of our previous jurors, which means we have to listen. What did I say? Did I learn from the consultant? They want to be heard. They want to be listened to. Again, not so much focused on making the ultimate decision, but they do want to be heard. They do not want to be interrogated. They don't want to be painted into a corner. So again, it's going to affect how we approach it in voir dire, and those are lessons, again, we take to other generations. One of the things that you have to be doing, and if you're not doing, you're making a mistake, is to learn as much as you can about their social media presence. I don't have Facebook. I have Instagram so I can see pictures of my kid when he went on vacation one time, and that's about it. But when you start understanding that people have multiple platforms, are they using that to keep up with their high school friends? Are they using that from a professional development standpoint? Are they using that to make statements that are consistent with their political views or their religious views, their attitudes, experiences, and beliefs? We need to find that out to the extent that our rules in the forum where we are allow for it. Here's the one thing. You have to be open, you have to be transparent, you have to be authentic. These kids will hold it against you, they will hold it against your client if they think you are trying to hide the ball, if they think you are trying to slip something past them. or if you're trying to cram something down their throat. So again, does that mean that an older generation does not want you to be open, does not want you to be transparent or authentic, and is waiting for you to tell them what to do? I don't think you can universally say that anymore. I have a 101-year-old partner who still practices law. We tried a $50 million case 3 years ago when he was 98, and he was amazing. But he had that old school bent. We were in a small rural community with an aged jury, and his style worked with him. It's probably, if he was still trying cases at 101, probably not going to have that same positive effect. So again, universal themes, open, transparent, authentic, are going to apply, I think, across the board, maybe more so than they have in the past, based on our access to information and media, including television. So what are we doing? We are engaging in short narratives. And I think if all of y'all will stop and think about the best trial lawyers y'all saw growing up, they were very rarely the men and women who spent hours and hours and hours with each witness rehashing the same material. I look back to my heroes, been my hero since I was 5 years old. I grew up with his children 50 years ago. And then I got the chance to come to work for him and try lots of cases with him. And, you know, he was the master of being able to look up at the judge and say, I have no questions for this witness. Or to say, you know what, I have 2 or 3 questions, and really mean 2 or 3, not the lawyer count of 2 or 3, which means 20 or 30 minutes. And I also remember, as I was a young lawyer, I kept getting car wreck cases to defend, and different partners would bring me different cases, but the common denominator was there was one plaintiff's lawyer on the other side. He was the plaintiff's lawyer that drove everybody crazy. And as I think I learned, he drove juries crazy because, you know, in a good basic case, he'd have a 3 or 4 hour voir dire. I came out of a prosecutor's office where my judge allowed me 30 minutes. And so you do 4 hour voir dire versus 30 minutes. So opening statement would be 45 minutes, mine would be 10. He would go on and on and on with every witness, and I would try to do the Jim Besserman way that I had learned and I'd seen it work. A few questions here and a few questions there. And I thought I was a really good lawyer. What I really realized is juries found me far less annoying than they found him. But that was in finding short narratives and respecting time. And now we lay on top of that millennials and others shorter attention spans. And I really think you have a trial strategy that works in the overwhelming majority of cases. We need to be presenting information in small chunks. We need to have narrative images, meaning pictures, whether they're actual exhibits or they're compiled demonstrative aids that tell a picture quickly, not in an hour and a half of testimony, but in one glance that can be remembered and that matters. We have to guide them in understanding and evaluating information and allow them to draw their own conclusions. You're going to hear that as we go through the rest of these slides here this afternoon. We have got to create a path without a hammer to hit them in the head. Big picture themes, they have to work through every stage of the trial. And again, what I hope you're thinking right now is, what about this doesn't work for any jury? We have to remember, they're multitasking. Anybody that's working these days, you're in a meeting, you're returning an email, a text, you're missing a call and you're texting that client or that person you work with and said, can't answer your call, what's going on? Again, that mindset tells us we have to keep their attention and we have to keep things moving quickly. We have to cue for them what is important, which is harder and harder to do if you are dragging out every part of the trial. If you're dragging out every witness, things get lost. The way to highlight your key points is to hit them and to move on. Think about just like we do an outline. We've got our bullet points and we're not being redundant. I remember growing up as a prosecutor, one of the one of the great DWI attorneys in this town, is I would ask all my questions of my witnesses, and then he would repeat them like in the exact same order. And he would do it in a very mundane way. And in the end, I think that the jurors, gave him some kind of credit in that he reinforced things, whether they were good or not. They must be good if he is going back over them. I think in this day and age, for him to sit there and double the length of a trial would risk offending jurors. Again, I think that's the way things have changed. Integrating technology. When you see the powerful plaintiffs firms, especially in personal injury, when you see the powerful commercial litigators and the success that they're having, you're seeing people that have absolutely mastered technology. And again, I think millennials expect it. They've never seen anything different. Other generations may have seen something different, but I think they have just come to expect it. Whether they may realize it or not, I think they will appreciate it. So again, timelines. I love timelines. I suspect most of y'all are like me. The first thing you do when you get a new case in, no matter what kind of case it is, medical malpractice, truck wreck, commercial, you are creating a chronology. My whole life revolves around chronologies because they do what? They help me understand my case. So why wouldn't they also help a juror understand your case? Concept maps to show relationships. You know what I'm talking about? All these circles with the lines that are showing us how everybody is related. I'm somebody that's read a ton my whole life, but I read for enjoyment outside of work, and I don't want to think a lot. And I get 40 pages in, and I can't remember who Johnny is or who Beth is, and so I write down the first time a character, Johnny. That's Dale's brother. And so if we can help them see those relationships, so they're not sitting there thinking, now how does this person tie back in? I can't remember. We are making it easier for them, and we are shortening the narrative that we have to deal with. Statistics and charts, if they're easy to read, if they make sense and they're not misleading, are the types of things that can replace minutes, if not hours, of testimony. Or they can supplement that testimony if it's still necessary. Appealing to justice and fairness, which again, when we're dealing with plaintiffs' lawyers, they're focusing on bias and fear and worry. We have to have something to balance that. And what we see with younger jurors is that they do value fairness, they do value justice, and so we have to tie into that to balance out that scale. What we see in the limited studies that are done out there is that idea of being a progressive, that idea of fairness and equality is something that you can tap into for your defendant. And this next point, very counterintuitive in my opinion, because you must present the evidence in an impartial manner. Now, does that mean straight down the middle? No, but it might mean more down the middle than what we have seen. Not the over the top, 100% we're right, they're wrong, to risk offending people. What we do is we paint that path. We ultimately are going to let them make the decision as opposed to telling them what to do. Okay, so damages. This is one of the places we really do have some empirical data that can guide us. And that is, millennials really are likely to award higher damages in certain types of cases. In cases where they're offended, in cases where they think there has been unfairness, that is a real issue. And so when you're looking at how to prepare your case from a damages versus a liability versus a mixed approach, you have to take into account that is a significant possibility. But you know what we're seeing in different industries nationwide right now, and in different kinds of cases, as we try to keep up with plaintiffs' lawyers, is we are seeing, you know, this idea of nuclear verdicts that are going around in the trucking industry, in the states that still have what I would call open and full medical malpractice. You know, those are very real issues, and millennials are a potential problem there. But again, you have to balance out that distrust of industries. You have to balance out that fear of safety issues, being a gatekeeper and a protector of the community that we see in the reptile theory. We have to balance that out with trust of our client. It's the humanization of our client as opposed to just some part of an industry. We have to refocus any outrage they have towards us, especially if you've got a case where personal responsibility is in play with the plaintiff. It is something that I have seen work, and I think will continue to work. Again, really just a summary there. And as we start running out of time, let me just move on to this. And so as we take these ideas from voir dire, from witnesses, obviously the things we're going to have previewed in our opening statements, again, we lead them to a certain result that we let them find it. I mean, that's probably, you're going to take one thing out of this presentation. If you're going to go read the articles that are out there, scholarly and otherwise, I think that is one of the real things that you got to be thinking about. We have to challenge them to make the right decision, the tough decision, that the system only works if our juries are willing to be a part of finding legitimate results. You know, part of every jury charge that says, you know, not base your answer on sympathy or bias or prejudice, you know, you can get there. And I've interviewed a lot of jurors afterwards, and it's always easier when you win to do that. But the theme that we continue to hear, and if you read what the jury consultants are saying, is you will see in a lot of big cases, we felt very badly for this person, that they're really responsible for what they did. And so then you take that and you say, well, in my case, I'm a commercial litigator, and that's not really going to apply. I think it can. I mean, if you have two businesses, you know, working together, and we obviously have some type of fallout, where is that personal responsibility? Where is that we're all big boys and big girls, and we can be accountable for the good decisions we make and the bad decisions that we make, and for mitigating when different things change. So, you know, if you're in an employment situation, you've got to find out how that personal accountability works, or some version of that argument works for you. Bear with me, I had a little delay there. Again, the CSI phenomenon, this is when I wish we were all in a room and I can say, how many of you have been to Vegas in the last 3 years? Kind of throw out the last year. If you take the 3 years before that and you've been to Vegas and you walk through the big casinos, you walk through the shop parts of it, what do they have? They have these, you know, CSI rooms. They have these places where you can go in and solve the problem yourself. You see lines of people lined up outside of them. And they are young, and they are middle-aged, and they are old. Again, tells us that it's changed what we're interested in. It changes how we view things. You know, we have to give them what they need to figure it out. And we have to do it effectively enough so that they can. Because if we have jurors that are lost, somebody in there is going to take that conversation and move it over. You know, what you really want are those 2 or 3 or 4 people who truly understand it in a way that they can replay it. You know, one of the greatest feelings that any of us have ever had is when you figure out, you're not always supposed to, but you can usually figure out based on a question, you know, that they're split against you, but you put the right information out there, and you've led some, and then they can lead the rest. So we have to give them that information. We have to establish trust, and we have to change the way that we deal with experts. Experience matters. What I see that doesn't matter as much to millennials and probably to others is somebody that worked for 2 years and has been a courtroom testifying expert exclusively for the past 20, 30, 40 years. They want people who are doing the job. They want people who can communicate, who can teach. You want an expert that you can just line up and they can handle. You have to manage every question and then leave somebody to have to understand what they're trying to say other than vote for Slater and Slater's client. You have missed an incredible opportunity. From that same perspective, the way that we attack experts, I think, continues to move in the direction of not necessarily challenging data points or little nuances, and that may be important and it may have to be done. But what we see jurors with short attention spans wanting is you got to challenge the logic. You've got to be able to say, this doesn't make sense because of A, B, and C. And you're going to get more mileage out of that approach than you are having your expert talk about millimeters or microseconds versus a different microsecond and how that plays out. And so when you can, you've got to find a way to have your good teacher, and then you've got to undermine their expert really in that similar manner. So how do we start doing this? I think it is easier to work with a jury with a short extension span from the defense perspective because we're hitting and running. We jump in, we jump out. We can shorten our voir dire, we can shorten our opening, we can shorten our cross-examination. We can be the good guys. We can be the good guys. I tried a federal criminal case a couple of summers ago and was blessed to get a not guilty. And I still think the reason is I positioned myself as the 5th defense lawyer, and I was able to ask one or two questions of every witness, and everybody else who went before me had to cover a lot of ground, lots of it necessary for the prosecution as well. But it taught me again, or reinforced that value of what matters and how can I be seen as a person that respects their time and in a sense can be the one therefore trusted. The idea of duplicating and repeating and having 6 witnesses say the same thing, it doesn't work anymore. What we do see that works is we may have 6 witnesses that all know about one certain thing. Let's focus on what they know that's different than what the others, or what they express best. And then if the other side wants to bring that out, all the better for us. So we kind of transition now and check my time because I don't know, we got to start late. And John was very nice. It was me that doesn't know the difference.
We got time, Slater. We got till about 1:30. So
I know. We're running a little late because again, I don't understand the difference between Eastern and Central Time, but we're here, and this part isn't near as long. So this idea of working with new judges, we all got older, which meant the judges got younger. And 15 months ago, I had the neatest young 9-year lawyer working for me. She'd come over. She'd been in private practice with herself, sole practitioner. And we learned about her and we met her and we hired her. And probably a year early, I just said, she is special and we're gonna make her a partner probably a year before. And she made it through most of that year and walked in and said, the governor has selected me to replace Judge Board. And so I'm gonna go be a judge. And I thought, oh dear, I'm not ready to be a grandparent kind of thought. The idea of I'm not ready to practice in front of my old associate. but that is what is happening. I do lots of administrative trials, and a lot of those are against the Department of Energy, and there were 5 judges for the first 20 years I did it. We did every hearing together with the same government lawyer, same me, the same 4 or 5 judges, and we all knew and understood each other, and we had ways of doing it. And they all started retiring, and we got new people, and they want it done differently. When I started, those took 2 to 3 days. We got them down to a day, and then we really got them down to half a day in determining what information was needed. The other day, I had a young judge, and I sent in my witness list of 6 people, which is about a half day. And she said, absolutely not. That's too many witnesses. Get rid of them. Start getting rid of them. Fortunately, the attorney on the other side said, you don't know, Slater, 6 is fine. But they are younger, and they have many of the traits that we've been discussing for the last 45 minutes. And so they have shorter attention spans. They are interested in doing right and in doing good. And we interfere with that when we don't respect that time. They do not have the patience of their predecessors. I grew up in a lot of what I would call county courthouses. I live in a town of 175,000 with 26 counties around me that probably don't have 10,000 people. And you would go to those courts, and the judges wanted to catch up, and the lawyers in the courthouse wanted to catch up, and everything was relaxed, and we could have long hearings, and everybody kind of enjoyed it. Not the case anymore. This new focus on efficiency and organization is reality, but I think it's a great opportunity for defense lawyers who have the resources, time and otherwise, and staff and young lawyers to help us put the best work product forward. And I'm seeing that gets a lot of respect from these young judges. They've come to these hearings much more prepared than their predecessors. For the first 20 years I practiced, there were no new judges around my part of the world. And you would go in, and it was very common for them to say, I've read the briefs, and so jump in the argument. You jump in the argument and say, okay, you caught me. I haven't read the briefs. These new ones, they can take that computer or that iPad home with them. They read those briefs the night before, and they are ready to go. They're not married to the way it's always been done. They love good briefing and good writing. They were raised with technology, and so they have access to it right there. You don't see going to get the file, from the clerk's office and the judge flipping through it. I mean, it's up there on their computer. They've highlighted what they're interested in. They're ready to ask questions, and they want to lead you, and they want you to lead them, but your leading is going to be before you walk into that courtroom. They do not want to be told what to do. The old days of judge, you have no choice but to do this, isn't going to work, because they're ready, and they want to get to the right answer, and they want to get there quickly. They're much more focused on case management scheduling. This is especially true as we see these young lawyers who are taking over for longtime judges, and they're coming in there and saying, we have all these old files. We're having a docket call, and stuff is being dismissed or set, whether we're doing it by Zoom or otherwise. They don't want scattershot. They don't want motions that cover 12 different areas when only 3 of them matter. The other thing that they want, and I continue to see with young judges, is they want structure in the testimony. We're not going to just meander through here and hope we hit the points. Let's go with the rifle, and let's have prepared witnesses and get them gone. Move on, get to the point. This is a part that is problematic for defense attorneys. I think young lawyers distrust dispositive motions and expert witness challenges, which means that in some of our legal communities down in Texas and around the country where I practice, every case has an expert witness challenge, whether it's legit or not, or multiple expert witness challenges. Does us no favors with this new generation. If it's legit, you need to get in there and be able to explain why it is legit. This next one I have added to this presentation because we have a new federal judge who is incredibly bright. He's 36 years old. And he doesn't look for it, I don't think, but he hears misrepresentations, and they are career killers. And that probably applies for any age judge. But it tells us we have to be prepared, no loose words, no meandering through a hearing where we say something we don't need to. Obviously, goes without saying, you have to show them respect. They require more preparation from us. They're looking for guidance. But again, that guidance needs to be before you walk in to the courtroom, because if you're waiting to change their mind or to have them make up their mind with what you say, you probably missed the point. It also fits in with this idea that we're seeing with new judges, much more willing to take things by submission and not offering the opportunity to argue. Now, one of the neat trends down in Texas, and I don't know if it's going on in Michigan, is the ability to call a judge and say, I know you said this is on submission, but this is an opportunity we have for a young lawyer to get some courtroom experience to argue. Been very receptive to that, both in the trial courts and the appellate courts, which is something neat to keep in mind. This to me is one of the biggest changes with young judges. They're ruling in the courtroom. You know, in the old days, the old timer judges, they'd say, thank you for a great presentation from both sides. You'd have your clients there. They say, I'll get a letter ruling put together and I'll get that out to y'all in the next few days or the next couple of weeks. A lot of times you get back to the office and it would be sitting on your fax machine. Really, that was a respect issue, I think, because judges didn't want to make you stand there with your client while you lost. That's not the case anymore. With the young judges we're seeing, they're very prepared. They want to make that decision. Down in Austin, Texas, our state capital, they have a rotating docket, and you might go to any judge for a hearing, and they will literally tell you, one lawyer sits here. If you didn't bring an order or a proposed order, one of you sit here while the other goes to the office and gets it ready. We're signing it today before everybody leaves. Again, very different as we move through. This is very hard to see. This is a young judge, federal judge we have in the Southern District of Texas down in Houston. And I think it kind of fits with what we're seeing with younger judges. It's an order. It says the court is in receipt of the parties' whiny letters. What is wrong with you parties / lawyers? Just stop it. There will be no extension granted on the motion deadline. Don't ask. This is my oldest and least favorite case. Please stop trying to become my least favorite lawyers. Happy holidays in all caps and bold. I think this is very insightful. When we think back to these last 3 slides, they are wanting to keep their cases moving. They will listen when you have a reason for them to listen. And if you're wasting their time, they're going to hold you accountable for that. So let's wrap this up with this last slide or 2. I'm telling you, I hope that as you have listened to this today, that you can see, or at least are willing to explore the idea that millennials are not outliers. They are the guidance that we need to be better lawyers. These discussion points that we have made today, other than just a few of the kind of around the edges points, I think they're universal. I think it shows us that stereotypes are not correct. It obviously shows, as it has for generations, that respect for jurors and judges goes a long way, but how we show that respect has now changed. We don't show up at court and meander through. We don't show up for a hearing and whine and meander through and try to get some love. We have got to come in there ready to go. Technology should be used to shorten trials, not lengthen them. Organization is never going to be a waste of time. We're going to focus on values that are important to millennials, and I think by extension all generations. And I think when we get to the end of this, when we realize this is half or coming up on half of our adult population in the next few years, these are people we have to understand, and there's no point in fearing them. There's no point in being worried about them, because really, if we highlight what we are doing and we do it well, it's going to appeal to them as well as others. That is my presentation. I talked very fast because I had us running late. I do not see that I am having access to the chat feature. John, can you tell if there are?
Yeah,
chat
I got it. Yeah, I
Okay.
got it. And we got some, and there are some questions here. Obviously, thank you, Slater, for coming and putting this great presentation on. One of the trends we're certainly seeing in Michigan, especially with regards to dispositive motions, is courts are just ruling specifically on the briefs, and that's with new judges and with older judges. Maybe that's because of the pandemic and the shutdown and all that. But with Zoom being so huge and remote hearings being so huge, do you see the courts kind of embracing that more and more so it becomes a permanent thing as opposed to being in person? Or what do you think about that?
So kind of two parts of that. So I think before the pandemic, we were seeing that fewer judges were willing to have hearings and listen to you. They were just going to take it by submission and they were going to rule. And I think the pandemic has just reinforced that. Now, what is interesting to me, because I think there is a school of thought out there that says, as our courts have become so much more familiar with Zoom, might there be a few more hearings? That trend we saw towards saying, nope, I'm just going to rule. Does this allow them to have a short 15-minute hearing where everybody doesn't have to drive? I don't think that's the way. I think you're going to see more and more have it by submission and make their rulings without hearing. I see it spreading over generations, but I think that is a function of these younger lawyers who are becoming judges and who are thinking, I'm not going to sit there and listen to y'all gray-haired people treat me like I'm stupid. I'm going to read your briefs, and if you gave me good quality, you're going to get a good ruling. And if you're wrong, you're not. I think that you're going to see more and more of that. And the truth is, in many of the things we do, as a much more efficient and cost-saving approach, for our clients. We all are egomaniacs. That's why we do what we do. And we always think that we can sway a judge. I think that's harder and harder to do.
True enough. So, obviously you've tried a ton of cases. Groupthink is kind of an interesting phenomenon when jurors get back in to deliberate. And it seems like there's a bit of split in millennials. They don't really want to make the decision, but they're very opinionated when it comes to certain things. Do you see millennials controlling the conversation back during deliberations, or do you see them kind of, sitting back and listening to the boomers or the Gen X's and then, kind of giving their response after that?
I don't see them deferring. I think that they will talk and in their own way lead, not necessarily as a leader, but they lead the conversation. And again, I think that they use a lot of logic. It may not be logical to everyone, but to them it's logic. And I think that they're not deferring like young jurors did in the past. I think they're back there and an active participant from the beginning and not the end. They want to be a part of the conversation from the beginning. I think that applies to the ones that work for us, not just jurors, but the millennial young lawyers who are working for us.
Interesting. One of the things that a lot of us on here, no fault litigation in Michigan is massively huge. It takes up a significant percentage of the court's civil dockets here. And a lot of the problems we see on the defense side is excessive charges by medical providers. Do you think that, millennials with their more perhaps liberal and progressive views, do you think that will help or hurt defense trying to show them that the charges of some of these medical providers are just way too excessive?
So there's two parts about excessive medical. And one is what I call the chiropractic approach with visits every day, to drive up bills. And the other is trying to rely on, a $7,800 retail charge that Medicare paid $18 for. In Texas went to paid and incurred is what's submitted to a jury. So the plaintiff's lawyers all just instructed their clients to quit turning their insurance in because they wanted to keep that number up. And our legislature meets every other year, and they're meeting right now. And I've had 6 meetings in the last 3 days with different groups, to try to figure out how do we manage that. And we don't have a great way to do it. I will tell you this, and I think this is how you change maybe how you approach that. If you're stuck with those, what you think is unnecessary treatment or unreasonable costs that are coming in there, I think you have to figure out how to approach that from a fairness standpoint and an equality standpoint. And I think if you can make that a trust issue, you might have some luck. What worries me is, when you see younger and more liberal or progressive, that are looking for, universal health care and stuff. And I haven't really thought this through, how does that apply? Because I could also see that getting flipped on you with that mindset of, why should anybody ever be out medical, and we're seeing that down in Lubbock, 2 hours south of us, home of Texas Tech. We're seeing lots of car wreck, what I call bad car wreck cases. The volume people with their almost in-house chiropractors, they're running up $8,400 worth of chiropractic care, and those verdicts are coming back $8,400, whether there's liability or not. And what that tells you is there is a hope or a desire to make people whole, even if we're not willing to enrich them. And I think that fits with the millennial approach. Kind of an off-the-cuff thought, thinking about that as I answer, but I think you have to look at both of those.
Well, and it's interesting you say that, because one of the issues we have here in Michigan, obviously, is, the plaintiff bar, and I'm sure it's the same all over the country. We try to keep these arguments out as much as we can, but there's a lot of judges who allow pretty much anything. They will argue to the jury, well, if the insurance company doesn't pay these bills, my client, who works, 2 jobs to keep her kids in school or whatever, is the one responsible for these. So instead of the insurance company, or instead of my client paying for it, you should make the insurance company pay for it. How would you play that with some of the younger jurors?
It's tough. It's tough. We had a famous case down here that was overturned on appeal and rendered with no liability, but it was a medical malpractice case. A doctor had $200,000 in insurance, a $2 million verdict, and the defense lawyer got on the elevator. One of the jurors, kind of punched him in the shoulder and laughed and said, "That's why we got insurance, right?" And it never is not in the jury's mind. I think it's never not in the judge's mind, and so I think that is tough, but I think that's when you got to swing these things back to accountability. And this idea of businesses ultimately are the ones that are paying. I don't care if the insurance company is. I think you just gotta think through that, and how do you change that to where what is fair and right is what's fair and right, not what feels better. But it's tough. All of these cases. I mean, if you tried a case, it doesn't matter that the jury charge says do not consider insurance. I mean, all that tells them is that there must be insurance. And that is tough. That is tough.
Sure. And there's a lot. There's actually one last thing. There's a lot of comments coming through here. Everybody loved your presentation. They loved your slides. They were wondering if they could get a copy of your slide deck to share with colleagues, or would you rather them contact you personally?
Anybody's welcome to contact me. My email's on there. I think I sent to y'all's organization a copy of my slideshow. Y'all can send it out to anyone you want. Yeah, that doesn't bother me at all. But yeah, awesome. I also know that sometimes there are questions. Yeah, shoot me an email and we will talk and go from there. But I really do appreciate y'all having me. Apologize that it was rushed. But again, I kind of decided I wasn't going to be pissed about millennials anymore. And that kind of is what drew me to this. And so hopefully y'all got something you can take out of it. And at least if it doesn't help you, maybe you're less angry.
That's perfect. Again, thank you very much, Slater, for being with us today.
All right. And y'all let me know if you need anything. Good luck and have a